5 seconds to go. Start. A close analysis of this decision would show that the following conditions must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of guilt is to be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is long and divides vague conjectures from sure conclusions. The facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved, and there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. These five golden principles, if we may say so, constitute the punchsheel of the proof of a case based on circumstantial evidence. This court has held that there has to be a chain of evidence so complete so as not to leave any reasonable ground for a conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. It has been held that the circumstances should be of a conclusive nature and tendency. This court has held that the circumstances should exclude every possible hypothesis except the one to be proved. It has been held that the accused must be and not merely may be guilty before a court can convict. It is settled law that the suspicion, however strong it may be, cannot take the place of proof beyond reasonable doubt. An accused cannot be convicted on the ground of suspicion, no matter how strong it is. An accused is presumed to be innocent unless proved guilty beyond a reasonable doubt. In the present case, we find that the prosecution has utterly failed to establish the chain of events which can be said to exclusively lead to the one and only conclusion, that is, the guilt of the accused. In that view of the matter, we find that the judgment and order of the learned sessions judge and that of the High Court are not sustainable. The appeal is therefore allowed. The judgment and order of conviction and sentence dated 11th and 12th January 2005 of the learned sessions judge Sonipat, and the judgment and order of the High Court of Punjab and Haryana at Chandigarh dated 16th March 2009 dismissing the appeal of the accused appellant Ram Niwas are quashed and set aside. The accused appellant Ram Niwas is acquitted of all the charges charged with. The bail bonds shall stand discharged. Pending applications, if any, shall stand disposed of. Stop.